Welcome to Beyond the Fine Print, the podcast where we help you simplify the ever-evolving world of commercial laws and technology and answer the major questions facing lawyers today. I'm your host, Rory O'Keefe, and in each episode, we'll be breaking through the jargon so you can stay ahead, keep it cool, and take control back. Now let's get started. Welcome back to Beyond the Fine Print. Now, today's guest might not be the Richard Ashcroft who sang Bittersweet Symphony from the Verve or anywhere else, but trust me, his impact on legal education and ethics is anything but bittersweet. In fact, if you're looking for someone who's writing the score for how lawyers are trained to think, lead, and judge, this is your guy. I'm joined by Professor Richard Ashcroft, Executive Dean at City St George's University of London. He's a bioethicist, a former Alan Turing Fellow, and someone who spent his career navigating the messy, high-stakes world of public health policy and institutional ethics. And now he's helping shape the next generation of lawyers. Ones who can handle ambiguity and challenge those pesky algorithms and actually think for themselves. So if you came here expecting a polite chat about compliance checklists, you might want to buckle up because we're diving into the big stuff. Questions like, are law schools keeping pace with disruption? Is AI helping lawyers think or just making them dangerously efficient? And what does ethical leadership actually look like in practice? So let's get into it. Welcome, Richard, to Beyond the Fine Print.
It's great to be here, Rory.
We're very honoured to have you here, especially for somebody who's in a very, very busy schedule, managing all the next generation lawyers. So I do want to get straight into it. One thing that's been on my mind, it's been kind of bugging me since this AI hype and this rush to new efficiencies creeped in over the last few years. The question is, are we still training lawyers to be agile thinkers, or are we just churning out glorified compliance bots? And I mean, the data is pretty clear. There was something I read recently from Thomson Reuters, and they were saying that 80% of legal professionals expect AI to have transformational impact to their work in the next 5 years. And lawyers could be saving 240 hours a year by just letting AI handle the grunt work. And to put that in context, I mean, 6 weeks of billable time, or 6 weeks pretending you're not working from the beach in Portugal. So AI is changing the game, but are we still teaching lawyers how to think critically, or are we just teaching them how to supervise the bots? Now, Richard, you've spent your career navigating ambiguity. And so the question now, especially for the legal profession, is what kind of mindset do lawyers actually need to thrive in this new terrain?
Because I work in a university, I start from what the fundamental purpose of a university is. The central thing for me is critical thinking. It is educating people in how to be open-minded, how to learn, how to ask difficult questions, how to discuss difficult questions with those around them, and obviously how to create new knowledge and how to have a positive social impact. But absolutely central is critical thinking. So if I'm teaching my law students anything, it's how to think critically beyond the textbook, beyond the page, beyond the judgment. And if new technologies are helping with that, great. And if they're getting in the way of that, we have a problem.
I was being brought back before this conversation. I was thinking about what was I like in university, and I won't answer that question, but people who know me know. But the point that I always got was, one of my lecturers at the time had said that they're not there in university as opposed to law school, but in university you're being trained to think like a lawyer. You don't know how to practice law. You're dangerous, and in some respects, because you've opened case law, you'll be able to look at the actus reus, the mens rea, you've been able to answer questions.
Yeah.
And it was interesting because I was talking to a doctor friend of mine, and she was saying that the process of thinking that we learned in university is similar to how doctors think as well. This is all just from one person. But the way is you take the facts, you take the law, you apply the law to the facts, and you come to a conclusion. Now, with the certain tools that you can have out there right now are suggesting we can do that. And they can come up with a conclusion based on the facts submitted against the law as they've interpreted against whatever data set that they've actually gleaned this information from. And I think that's quite linear, because what we're avoiding is the human creativity, shall I say. And it's hard to apply creativity to lawyers because we always say, oh, we're not the creative souls. We just think of arguments and we think of both sides and live in the grey. But the reality is that we are taking ourselves into a new territory where we have to analyze the law, because we know, especially in common law jurisdictions, that just because the law said this is the case or this is a position 2 years ago doesn't mean that's it and that's the law.
Yeah.
But the question, because society moves, we move. So the AI bot that's being used is only as good as the data entered. So, and I tell lots of people, as soon as you've entered the data, you're out of date because everything's moved forward since then. Mm-hmm. So and this idea of machine learning, and it's because the machine learning element is going to drive that judgment, that analysis. But I always question it, the nuance of the lawyer coming through their thinking, the ingenuity of coming up with just that argument, which nobody ever thought of before, and went, actually, yeah, there's a different way of attacking that problem, which we hadn't thought before. But this person over, this barrister, this solicitor, fantastic job done. But like, for your perspective, it's like, what are you hearing from, the students coming through in the university? Like, what's their viewpoint on how AI is changing the way that they're delivering work? I suppose another way of asking it is, we've all heard the classic stuff of saying people using AI to write their essays, and then tutors using AI to correct the essays. And then you kind of just say, why don't we just take them both out and just get the two tools to talk to each other and give you a mark? Yeah. What are you hearing on the ground from?
One thing that we're all talking a lot about in universities at the moment is student mental health. We have an anxious generation. We have a generation whose education in schools has been highly disrupted by COVID. We have an employment market that is difficult. We know that students are anxious about being able to get on the housing ladder, and so on and so on and so on. And that's before we even get into the existential stuff around climate change and global politics and so on. So they're anxious. In a situation of anxiety, what do? You take whatever steps you can to reduce your uncertainty. And some of our students are approaching AI in that way. They assume that if they type in the prompt into the chatbot in the right way, they will get a reliable answer. They probably know that they won't get top marks, but they'll get good enough marks to allow them to move on to the next thing. Some students are seeing AI and large language models as exciting new technologies that will disrupt the future of legal practice and society more generally, and they're embracing that. And some students are obviously quite skeptical about them because, a lot of people are quite skeptical about them. So you get different responses to the possibilities of the new technology. We have some students who are able only to access the open access technologies, ChatGPT, etc., and some who have been able to purchase licenses for the industry standard tools through Westlaw, LexisNexis, etc. And we as a school have taken a decision that because we want students to be using reliable legal industry tools, that we will purchase licenses for a proprietary system. The thought being that if they're going to use it anyway, let's make sure they're using a good system.
Yeah.
And second of all, if they're going to be using this tool when they move into, let's all hope, employment, it gives them an edge if they can say, we're already familiar with this and we know how you use it. So we teach people how to use these AIs rather than just allowing them to discover them. So as well as, addressing student anxiety, we're also trying positively to lean into it around the employability and skills agenda. But against that, we also have the critical thinking responsibility to ask questions about, are these technologies as reliable as they claim they are? Do they actually answer all the questions that a client might have of their lawyer or another lawyer might have of a colleague or an opponent? And what are the downsides of these technologies? Both in terms of, do they generate accurate legal understanding? Do they make efficient use of resources, etc. So we try to teach students around all new technologies. How do they work? What are they good for? And what are the downside risks?
I think that's music to my ears anyway, because just to put in context for our listeners, what they're looking at is things like succession planning, recruitment. Mm-hmm. Some will be fortunate enough to be big enough to be able to bring in trainees. Like an in-house can also have trainees as well. So you're looking at that from that perspective. But you want to be able to to believe, like when I was going around looking for different jobs, the first thing was that you have computer skills. That's all you had to write. I have computer skills. They never really tested me on spreadsheets, thank the Lord, because that's not my forte. Word, very good. Excel, it would take a little bit longer. And thankfully, the AI tools allowed that will create the spreadsheet for you now. So that's actually handy. Skip through it. But the positions now that we have is that people are trying to see, so what's out in the market? Are we getting the right kind of graduates, the right skill sets? I know some of my colleagues are talking about soft skills as being an area which people need to use because they are aware of the anxiety, the wellness, the health, well-being. Some people out there, I always say to people when they say I'm just an anxious person, I said, no, you're not an anxious person. You're probably anxious about what though? And once you understand the what, or you're anxious because, that gives a context and gives you control. So you need to start facing what those triggers are in order to kind of be able to overcome them. But it doesn't necessarily mean everything because of the problem. Because it is important for lawyers to, because you mentioned it, uncertainty, to be able to tolerate that sense of uncertainty. I think in the past 20 years, we used to talk about stress as positive stress and negative stress.
Yes.
You know, where you fall over, you go into negative stress and you don't become a very, productive lawyer then, and because you're not as focused. But I like the way you're doing. But there was another thing you mentioned, which was judgment. And I want to talk a little bit more about judgment, especially judgment in the age of AI.
Yes.
Because AI now can draft contracts. Not very well, by the way, just people are using it.
Yeah.
They can summarize cases, kind of, and even pretend to care about GDPR, which is very nice of them. But when the machine says yes, and your gut is saying absolutely not, what do you do? And there are some tools that are so confident. They're making ChatGPT and others like that sound like their overachieving cousin who just discovered LinkedIn Premium. The type that I'm thrilled to announce I've automated my entire personality, that kind of thing. So like Richard, you've spent time, even at the Alan Turing Institute, I have huge respect for that group, and you've been working on ethics and healthcare. That's a minefield in itself, just for the AI in healthcare. That's a big conversation, which can't get into now. But what can legal educators learn from this world or this new world? Because I know City St. George's, you're already thinking deeply about how to integrate ethical and digital literacy. Yeah. So tell me more.
I spent about just over 15 years in medical education before I came into legal education. And I've always found the contrast and comparisons really interesting. So one of the things that I think legal education hasn't really learnt from medical education and should is that what you're taught in law school is out of date even before you leave the building. It's in medicine, they've embraced this for a generation and more, that the evidence base of how to treat patients, how to diagnose illness, how to manage public health risks and so on is continually changing. There's continually new scientific knowledge, and you need to be able to take a scientific paper or a medical textbook and say, well, is this actually true? How do we know? What's the latest evidence? What don't we know? Where are the uncertainties? What are the new questions? And in medical education, there's been a strong strand of trying to teach every doctor to be their own researcher, which doesn't mean what it means on the internet. I did my research and I can tell you something about how Donald Trump is a lizard. Donald Trump is not a lizard. It means how to frame a question, how to understand the tools that are available to you to answering that question and testing whether you've got the right answer and moving on to the next question. So when we teach law students, we have to be able to teach them how to understand a legal rule, but also what that legal rule doesn't cover and where it maybe breaks down, and how Court of Appeal judgments can change what you thought you knew more or less overnight. And Parliament can legislate and change what you thought you knew more or less overnight. So dealing with uncertainty as a feature of legal practice rather than as a bug is the first thing. The second thing that I think is really important that they get not right in terms of not absolutely perfect, but they do talk about this a lot in medical education, is how to work with your patients. Communication skills are absolutely central to medical education, more or less from day one. And how to understand your ethical obligations and live your values as a doctor or a nurse or a paramedic, whoever. When I came into legal education, I said, okay, I've spent 15 years thinking about ethics in medicine. It would be nice to teach legal ethics. And I said, would anyone like a course on legal ethics? And I got people just looking at me as if I said something really weird.
So what language are you speaking there?
Yeah. I would have been a judge, but I didn't have the Latin. So what I quickly discovered was, first of all, most law schools in the UK, the professional practice of the law is outside. What we do in law school is almost an academic subject. It's a liberal education. It's a theoretical education, but it's not about how do you do law in reality.
Yeah.
Do bits and pieces around pro bono and mooting and so on that give a flavour of it, but the actual practice of law is outside of the halls of the legal academy. There are exceptions. My own school is an exception. It has a very strong department of professional legal education, but a lot of law schools don't have that. So thinking about legal ethics, we're seeing, that's a professional matter. We don't do that. When you do get into teaching people professional legal ethics, it's, as you said earlier, a lot of it's about compliance. It's not about values. It's not about thinking for yourself. It's not about saying, these things I will do, these things I will not do, these interests I will represent, these interests I will not represent. And it's, at best, it's about saying, well, there is something called the rule of law and it's really important. And we are officers of the court and that's really important. But you quickly get into, what does the Bar Standards Board Code of Practice say on this question? Or what will land you in front of the Solicitors Regulatory Authority? And it does what lawyers do, which is take a situation involving judgment and experience and turn it into a set of rules. And I would say sucks the life out of it, because it doesn't help you think, what kind of lawyer do I want to be? And what can my client expect of me as a practitioner? The other thing about it is that very rule-based approach is essentially retrospective. One of the things I find fascinating about the law is it's always looking backwards. Nothing becomes a legal matter, well, not quite true. Probably not true for in-house lawyers, but for a lot of litigators, you have a fact situation which you then try to turn into a set of legal facts, which you then apply a set of rules to. That's already happened. The same seems to be true of legal ethics. You've got a set of rules which apply to a situation where something has purportedly already gone wrong. And it's hard to read off those set of rules. What do I do next time not to be in breach of these rules?
Yeah.
If you see what I mean. So in medicine, you're trying to think about how to make decisions that are going to be the right things for the patient or the right things for society. And if you're thinking about public health, and it's essentially forward looking. Whereas legal ethics seems to be essentially backward-looking. I've probably painted the contrast too brightly, but I think the contrast is real enough and it's interesting. So what I want is a legal education that learns from medical education in this respect. And I'm training students not only to think for themselves about what is the law and is the AI telling me the truth about it, but also what is the right thing to do in this situation.
There was a few things there that kind of caught me of interest. It was like what you were doing there. I think it was my history teacher. He took it from, was it Churchill or something? He said, if you don't learn from the past, you're doomed to repeat. I'm sure that somebody can say it more eloquently. So for law, we've always taken that we need something to ground us, some foundation to work from. And the thing which I always remember is like sometimes there's key cases that we know change the law. Like we all talk about it, Donoghue, Stevenson, Hadley, Baxendale, yeah, etc. And then there's tons more. But they're the obvious ones that you start with as a law student. But the point is that these were fundamental shifts in thinking, which came from the past, which you then move forward. But in order to shift the thinking, somebody had to think it up. It wasn't just the judges or the respective. So when you got to the stage of looking forward, I think, yes, in-house counsel are better placed to do a lot more forward thinking than litigators. But I do have an interesting thing, because when I was in one company and we were testing a particular position that we had within our contracts, and it took us about 2 weeks, if not more, to argue and get the point there. And everybody it drove the good relations, the credibility, all this into the ground, because we had to argue a point which was just driving everybody insane. Nobody wanted, nobody cared about it. But then we asked a simple question. We asked the litigators to say, so since the last time we got stung on this point? Have we had any repeat cases? The answer was no. When was the last one? Oh, it was about 10 years ago. So do you think we could drop this as an issue? Maybe we could find a formulation which actually would remove this friction point and save us 2 weeks of our lives. And everybody just thought we're being very selfish. Yes, we are. We're lawyers. We're human. But the idea is that we wanted to get something done, but we asked the questions of the litigators. But for everybody who does contracts, you know that the only time when you really, truly know if your contract will have any real weight to your drafting is when a litigator picks it up and starts poking holes at it. I have seen barristers who are brilliant at grammar and they'll pick holes at the simplest of things. A comma in the wrong place will throw everything out.
Yes.
But in-house, we're rushing through contracts so much so that we don't have really time to pause and think all the time about what a litigator might do with this contract, because really the only time the contract needs to be read is when somebody's done something wrong. So you have to have faith that the people delivering the contracts are pretty much going to do their job and do it well. Then everybody's good. We continue on. But it was a lot of interesting about the ethical piece, because I was curious, trying to think back what element of ethics I had to do. Now, I didn't study in the UK. I was in the Irish and UCD, and then went to Blackwell Place, which is the Irish place for becoming a solicitor. I did a little bit in Cambridge. No offense to your university as well, but it just happened by pure chance. But the ethics piece was a short module. And then when I was looking at the New York Bar exam, they have their own actual full section, full examination that you have to do on ethics, which is a very interesting approach they've taken, because it's that with these algorithms, you know, the question is that lawyers need to interrogate the tool, not just use it. And for me, that's ethical literacy, not just digital literacy.
Yes.
So in order to get us to that, we need to know where our compass lies and where we see that ethical kind of question being resolved. Because in-house lawyers have those questions where they're an officer of the court, but also they're an employee. So they balance that equation, that weighing scales, that justice scales in a sense along it. And I always mind when people ask me where I'm going from this one. I say, well, I did 6 years in criminal law at the beginning of my career. And when you've got a client who's guilty, you know, and you don't ask them the question, are you guilty? Because if you get that answer, you can't put them in the witness box, because it's perjury if they lie. And because you're aware of it, as an officer of court, you have to make it known. So rather than risk any of that, or coach, which you can't do in this jurisdiction, for anybody loves that idea in the American court. No. It's not allowed ever. So you get into that situation where I can't put them in. But then the other question was, well, you know, why is it that in some jurisdictions you can pick and choose who you represent, because you're going to pick the ones that you're going to successfully win.
Yes.
But it comes back to your point. There's the rule of law. And the master, I know we call them differently now, but he was the master and the apprentice, right? So the master I had, and I'm showing my age, is simple enough. He said, our duty is always to test the law and put the best case forward. Yes. And then wherever it falls, it falls. Yes. And the thing about AI analysis is that sometimes you went from the High Court to the Court of Appeal, and the Court of Appeal overruled it on a technicality. But to a bot, it can sometimes say, well, it was overruled because it was they lost on these major points. I said, no, they didn't lose on the major points. They just brought the wrong set of facts. It just wasn't ready for it. You'll have to find a better plaintiff, or you'll have to have better. There was too many anomalies, you know, which was the reason why the Court of Appeal overruled. It wasn't because the analysis or the arguments weren't sound. It was just lots of other extraneous factors that caused that to fall over. So when you think about it, you really need a human person, a lawyer, to interrogate, to say, okay, didn't get it today, but I might get it with the next case in the future. Yes. It's that kind of thinking that you want from the law students.
Yes.
To really just feel that, okay, it's never clear, and you really need to know. And ethical questions are sometimes very, very hard to navigate.
That's right.
But don't be afraid of it.
No. I think, well, two things from what you've just said. First thing is again common between law and medical education. One of the things medical students are most worried about, because they are working towards becoming a registered medical practitioner, and getting that registration is the thing that will allow them to practice as a doctor, and they hope for the rest of their careers. They've worked extremely hard from it. The one thing they worry most about is losing it. Not most. I mean, obviously they worry about patients dying and those kinds of things, but they know, being medical students, that sometimes patients do die. What they don't want is the patient died because of something they did. They don't want to be in a situation where they have committed negligence or professional misconduct. They don't want that.
Arguably, just to point it out, that for a criminal lawyer, they don't want somebody to lose their freedom.
Right.
Because of their own mistake or error.
Because of mistake or error. Or
it's not as major as a loss of life, but it has a comparison there.
It has similar impact. So they can sometimes be in a mindset where, tell me what it is I need to know so that I can't be struck off by the General Medical Council. Tell me what it is I need to know so that I won't be liable in negligence. Yeah. And I think this similar thought does cross the law student's mind as well. They can see ethics and professional regulations as, in a sense, defensive. It's about protecting them from disaster. There's a more positive way to see these things about, well, you want to be the best lawyer you can be. You want to be the best doctor you can be. You want to do the most good for your patients and so on. That I think is a better way of looking at it. But quite often I just have to walk students through. This is what you need to understand about the way the law approaches negligence. This is what you need to understand about professional regulations. And then, once I've satisfied their anxiety about those things, then we can go into the more positive conversation. The other thing that I just wanted to pick up from what you said is the point you were making about, well, how a legal matter can proceed from the first instance court into the appeal court. And sometimes you'll win on a technicality or lose on a technicality. And sometimes the judges will take an opportunity to restate the law. And you get genuine legal change arising from an appellate judgment. And all my undergraduates ever really see are appellate judgments in the textbooks and so on, because that's the case that's defined what we should think about consideration, say, in a contract, what it means for there to be mistake, and so on and so on and so on. They don't really understand how legal matters end up in the appeal court. And they sometimes get the idea that appeal courts are, all law is like appellate court judgments, and it's not. But one thing you do learn from looking at appellate judgments is that the law is an open system and it can change. And what you thought was the rule is no longer the rule. One of the risks of relying too much on your large language model is they are not set up to tell you what might be different. They're set up to tell you what we are currently saying. So it can throw out all sorts of answers that might turn out to be what a court judges, but it can't tell you what a court will judge. And it can be very misleading that way. I mean, we can talk about hallucinations and all the other ways, just makes wild errors. But what it can't do is think and understand. It doesn't have a grasp of meaning, and it doesn't have a grasp of nuance and context and so on. It can simulate those things, but it doesn't have them. Whereas the human lawyer has to develop those skills of understanding why a client wants the thing that they want and what might be an outcome that could be acceptable to both sides in a negotiation, and where the law is sufficiently uncertain that we really need the courts to pronounce or for Parliament to legislate and so on. So those kind of uncertainties or decision points, that's where the legal judgment comes in, and simply having a automatic jet text doesn't actually tell you. It just gives you a space of possible outcomes. So I suppose one thing I think about all this is that what the AI will give you is a first draft. And if you're the sort of student who hands in your first draft, well, good luck to you. You're not going to get the best possible answer, and you're not going to have understood what it is you've said and where it breaks down and where you might want to refine a point or reorder it or do it differently or take another opinion. And a lawyer who hands in their first draft is probably not a very good lawyer. Obviously, if you're a junior barrister and you're picking up some criminal cases and you have to represent them very quickly, then you might have to be that person and do your best in the magistrate's court or in the Crown Court. And I think one area where we have to think a bit more deeply is where lawyers are working at pace. They're picking up a brief and they're having to represent a client with no time to process it. How do we ensure that they're doing that as well as possible? And I think we need to be a little bit more analytical, perhaps, about the different kinds of legal work and where AI can assist that or impede it, rather than just saying, there's the law and there's AI and it's all going to disrupt it and it's all coming this way or that way. And, well, no, because actually there are different kinds of relationship with a client, different kinds of legal matter, different time scales on which people are working.
Yeah. The ethics question, if you kind of take it out of the AI arena, just bring it out more broadly, we've seen an awful lot just very in the recent past around corporate scandals, data breaches, and the occasional oops email sent to the regulator. Because ethics in law feels less like a compass, more like a weather vane at this point. So you have, just to talk about it, you've got the post office inquiry.
Yes.
There's over 20 live investigations into solicitors and law firms. You got Axiom left about, I think it was £60 million black hole, and the SRA's fined firms for anti-money laundering failures, and also please everybody stop using the client account. It's not yours. It's basic 101 for accounts. But that's not really ethics. It's more like a forensic accounting and a side of regret. But here's the thing, ethics isn't just about avoiding trouble. It's about building trust. It's leading with integrity, making the decisions that hold up under scrutiny. So you make the decision now, and in-house teams are creating policies and we're creating particular playbooks, etc., which needs to stand the test of time. So if you can test this in 5 years' time and say, yes, I understand why I made that decision. We've moved on from it because, and then that's fine. But I know this is something that you talk a lot about, but is there a way in which we can move ethics from the margins and into the centre of legal education? Or have you already done it? I query.
We haven't yet. I mean, in my law school this month, we're launching a new undergraduate law degree, which is our existing LLB degree, but with a totally rewritten first year, which is putting sort of academic skills front and center. So we have a new module called Foundations of Legal Knowledge, which is about introducing people to a lot of different ways of thinking about the rule of law and legal rules. I'm doing a lecture on law and morality. There's a very famous thing that judges say from time to time, that this is a court of law, not a court of morals. And I'm going to be talking for about an hour about what that means. So I won't try and summarize it here.
My old boss in civil litigation used to say, principles have no place in a court of law. And I always kind of went, that sounds wrong. Sounds really wrong. But what he meant, I always later understood, was that if you're taking a court case based on principles alone, it's going to be very expensive. You may win it, but you get nothing really out of it. And I was like, okay, but that question about access to justice, the purpose of the judicial system, it raises so many other questions. But he was thinking it from particularly just a grassroots, pragmatic approach to it. I went, okay, I get it. It's just not where I was coming from. But then I was quite green behind the ears at the time.
I once had an argument in print with some colleagues about whether there are principles of medical law or not. And you might think that as a philosopher, I would say, yes, I would hope there are, respect for autonomy, for example.
Yes.
But as a non-lawyer looking at the law, I tend to focus on the things that I think are distinctive about the law, as opposed to looking at law as simply kind of bad philosophy. It's good law. And you have to look at how law is made, and it's made through the created wisdom of the common law down several centuries. It's about each bit of which has come out of a case that was decided at some point. And then you've got statute law alongside that, and you construct what the rule of law is in a particular case by looking at the way in which that long line of cases and bits of legislation have come together to give you a rule on a point. That's a very different way of looking at things to saying, right, here is a principle, and the way we interpret that principle in this case is as follows. I mean, they tell me, I couldn't comment, that the civil law is more like that. But the bit of English law that I've spent most of my time thinking about outside medical law is human rights law. And when I first started thinking about human rights law, I thought, this is the thing for me, because you've got, 12, 14, 15 different rules, which all seem very obvious what they mean, like the right to private and family life, for example. And then from that, you construct what the architecture of the legal system is. Well, that's not actually how human rights law works at all. But it looks that way. I mean, it looks to me, as a former mathematician, like a set of axioms, and then you can construct the whole of Euclidean geometry from your set of axioms. You can construct the whole of English law from human rights principles. Well, no, that's not how it works, because of the way the common law takes material and turns into decisions on the other side. So we're trying to get students to think about, well, what do they think a legal system is, and then lead them gradually towards what the legal system actually is. And you go on a sort of two-step in legal education. The first step is you have real-world situation, and you somehow have to turn it into a lawyer's representation of that legal situation. And then find the legal rule, apply it to those facts, and that tells you the answer. And then the second step is to unpick all that. You say, well, why is that the legal rule, and how could it change? And does it create problems over here that we haven't thought of? And that's what we do over the course of 3 years. You build them up, and then you take it to pieces again. What you can't do is leave them on day 900 where they were on day 1, because they have to learn how to think like a lawyer, what a legal rule looks like. There is a core of knowledge you need to have about contracts and torts and crime and European law and so on. But they have to be able to use those as tools and understand them as the imperfect tools they are, rather than just saying, well, I think this is unfair. You've got to do better than saying, I think it's unfair.
Okay.
That's day 1. As an in-house lawyer, you're doing this all the time, I guess. You're talking to your colleagues about who don't know the law, and they think you're going to tell them what it is.
Because it's always clear.
Always. And if it's not clear, then they'll get a better in-house lawyer in who will tell them something different.
That's form shopping, and it still happens all over the place.
Of course it does.
but
you have the ethical challenge, and I dare say this is part of what went wrong in the post office thing. Is after a while, you start to think like your colleagues more than you think like your legal peers, if you're not careful.
I call that going native.
Yeah.
It's hard to do because you have an employer, you're learning everything. You maybe built up even 10, 15 years of loyalty with them, and they've helped you through with a very successful career. So when they say they want to do something, you want to make it happen for them. But your objectivity needs to be retained and respected. Like it's sometimes I kind of, like, it was when you were talking about legal principles, I immediately thought of equity maxims. It's comparable, it's not the same, but it's an interesting blueprint that you can apply to testing your thinking. Within university, when you talk about these scenarios and asking people to think, one example I think came up quite a lot about 3 years ago is when we were talking about autonomous vehicles. And so if they have a choice between running down one gentleman who is a billionaire against 2 people over there who look homeless, but the gentleman over there is now actually walking with a child, but the 2 homeless people have 3 dogs and a granny, which one does the car bump into? And the answer is say, well, it doesn't. For starters, it just breaks.
Yeah,
so
that's right.
Please brake. Or destroy yourself. But there's a person inside the car. It's like, so you've got all these questions saying, well, so what should the rule be? And you go, it's an interesting hypothetical, but you can see it becoming a real life thing. But when a regulator,
it's really interesting because that example is a version of what philosophers call a trolley problem. And traditionally, you've got a trolley or a train running down a track, and there's a set of points, and if it goes down one way it'll run over one person, if it goes down the other way it'll run over 5, and you can pull the lever to divert the train onto which track after the set of points, and you have to decide. And people debate this endlessly. I mean, I've seen books of 400, 500 pages talking about all the different fine variations on this. The too long didn't read version is there is no answer to this. All it tells you is what values you think are most important. It might be something to do with fairness. It might be to do with minimizing bad consequences or maximizing good consequences. And ethical philosophers can talk about this for literally hundreds of years without coming to a final conclusion that everyone agrees on. The scary bit is that this has been taken up by engineers in Silicon Valley and somewhere else as, actually, this is quite a good way to do engineering. Well, no, it isn't. It isn't a good way to do engineering. Turning philosophical thought experiments into very expensive vehicles whizzing around in California is not a great way to develop a new technology. You should find a way to avoid that being a problem in the first place, as you say.
Yeah.
Make sure the car has brakes, and that if something goes wrong, have a system of legal rules about who is to blame and what consequences flow from that.
Yeah. No. And I was just thinking about, like, although I live in London and I'm not a huge fan when it changed, but I understand the logic. It went from 30 miles an hour to 20 miles an hour all the way through the city.
Yeah.
All because to reduce the number of accidents on the roads.
That's right.
Environmental emissions, etc.
Well, that's a really interesting one for me, as I rarely drive, and when I do, it tends to be a car club car. And what I notice is that cars are not engineered so as to be able to go comfortably at 20 miles an hour.
Great, yeah.
Now, in most of the places where they have the 20 mile an hour zone, that actually it's a good day if you're able to get up to 20 miles an hour because you're in continuous slow moving traffic.
Yeah.
But nevertheless, it creates a difficulty in the head, as it were.
What I was thinking of before was, regulators for in-house teams, regulator calls. They're not going to be asking about a hypothetical with the footnotes that we talked about before. They're not going to say, what did Lord Denning do? What would he do? What did Lord Atkins say? It's saying, who approved this? And why is their phone switched off? That's a bit suspicious.
Yes.
So it's trying to help young lawyers to navigate the moral grey zones and corporate chaos and the speed at which you need to resolve things when you're an in-house lawyer. And for a lot of junior lawyers, when they go into in-house, they're usually got a senior there who can lean on for experience and understanding, who make the bigger decisions. But sometimes they're going into startups or scale-ups as the first lawyer, and they feel confident because lawyers have this sense of pride, but also pride that tells them, I must know the answer. And I must be able to find the answer quickly. And once I have an answer, that must be the right answer. But without giving themselves pause to think, to say, what is it? Should I check it with somebody else first before I go ahead? It's just this sense of, we talked about one of our earlier podcasts, I think it was the line mentality. Just trying to kind of push yourself forward because you need to show that you're brilliant. Because you're a lawyer. You've got the qualification now. Everybody's expecting you to have all the answers. But also it's a respect to the fact that sometimes you don't have the answer. And actually, the ethical choice is to say, pause, I'm going to have to research this and I'll come back later on. Or pause, come back later on saying, we need external counsel view, or there is no answer to this, by the way. So this is all new for us all. So it's just being able to deal with those real world complexities. And I think that's part of the training for lawyers.
It is. I think there's another thing which is interesting to me about working as an in-house lawyer, which is if you're a junior or a partner in a law firm, you are a fee earner. You are contributing to the business directly. If you're in-house, you're in a different position. The fee earners are the engineers or the people in marketing and so on. You're providing the professional services support to the operation. So there's a certain pressure on you to say, I am adding value here. And I am adding value by enabling you to reach your goals and not wanting to be seen to be getting in the way of
a blocker.
Yeah. So you find yourselves in the compliance team, in the finance house or the HR team and so on. There's always a pressure to say, we are not here to stop you doing good, profitable things. We are here to help you do good, profitable things. And reminding people that you can't do good, profitable things if you go off that particular cliff. And by the way, you are directors, you have legal duties, you can end up in court and you could end up in prison if you do that. So don't do that. And balancing all that is presumably a challenge that's rather different from the challenge you have if you're a partner in.
Yeah, agreed. I did have to have a conversation with a very senior individual in a company I won't name, but I had to say it was something as simple as backdating a contract. And I said, you don't backdate the contract, you just change the effective date. So we'll have to get both sides to agree to rip up this contract, and that's there just on the basis that it's a typo. Or you can do a amending restatement agreement, whatever you want to do. But we have to change that because it's also with a government entity as well. So it's in their best interest. So if they ever got a public audit committee coming forward, then they can explain it logically and legally. So huge resistance. I was very junior. I was going, there is something wrong with this. Why is it wrong? Why is it always that we've always said you never backdate a contract? I for some reason, it just escaped my brain because I was being put under serious pressure just to accept it, say nothing, move on. But I said no. And I did a bit of checking. And then I came back and I said, no, you're going to have to do this. It's in both your interests. And he said, but it's going to look embarrassing for us. I said, don't care. And he said, but what is it? And I said, well, why do I have to do this? I said, well, because it's fraud. And I learned the trick from an old person who said, it's the yes and. Yes, we can continue with this contract. And because it is fraud, it will mean that we'll need to inform the directors of the company that they may be held criminally and personally liable for should this arrive. If an action is taken, of course, criminal liability includes both a fine and or conviction with the criminal prison sentence. So would you like me to issue the notice to them or not? Obviously, this was the most passive-aggressive, condescending approach you've ever taken, so please don't follow my rule. But I was fed up with this individual who was so full of his own importance that I was like saying, I said, well, what is this? I said, it's fraud. And he said, don't use big words with me. And I lost my cool and I said, it's 5 letters. And I was just going, because I was fed up and saying it is fraud. So let's not go down this path. But I said, if you want to, these are your options. And of course, yes, it was all resolved. And then the final document was signed, was kind of dumped on my desk with no grace whatsoever. Yeah. But that's what you need is, maybe it's because my days in criminal law kind of led me to deal with kind of that kind of character. But it was kind of interesting that you know, sometimes when you're right, you're right.
When you're right, you're right. And they don't thank you for it.
No.
They don't think, oh, thank you for saving me from that disaster that never happened.
Yeah, because they just say, well, I just lose my job, move to the next company. I said, oh, okay. Well, you might want to put a few trips into the local His Majesty's Prison Service at some point, just to apologise to the directors when you're visiting to them, you know. But asking you just to move into a question, which is, it's quite bold, so forgive me, but is academic legal research genuinely useful to practitioners? So I'll be honest, some of it reads like it's written for a symposium that would be held on Mars.
Sure.
It's dense, it's theoretical, and it's about as boardroom ready as a Latin textbook.
Yes.
Okay, so I don't think that it's the issue with the research itself. I think it's in the translation. And
yes.
Is there something we need to bridge between the scholar's thinking and the commercial decision making? Is there something there that we can make this more of the research to point to the real world consequence? I'm not saying all, by the way. So anybody who's listening to this, honestly, your papers are amazing, wonderful. Don't send them in and just say, look what I did. And it's yeah, I appreciate it. But it's just, is there something more we can do to bridge the gap between academics and practitioners?
Not all legal research is useful to anybody, including other legal researchers. So quite a lot of papers published in law journals are cited never, even by other legal researchers. I mean, you don't know that when you publish the thing, that it's going to fall completely dead-born from the press, but it's not infrequent. Quite a lot of legal research is useful to other legal researchers because we're working out something and it's not intended to be applicable. It's meant to continue a conversation in the legal academy about human rights or international law or fundamental principles of contract or whatever it might be. But quite a lot of legal research is at least conceived by the academic researchers as they are trying to contribute something to the world. And sometimes they're trying to contribute something that's very critical. You know, the stereotype academic leftist who thinks capitalism is bad and it should be abolished and so on. There are such people. And those people are, of course, not intending that their work be useful in the boardroom. Quite the opposite, if anything. But let's focus on those who do want to have an impact on the world of legal practice. A lot of them don't know how. They have something useful to say, let's say about employment law, but they don't know how to translate it into language which is useful and meaningful to practitioners and policymakers. So one of the things that universities have worked on quite a lot down the last few years in particular has been to try to bring people together from the worlds of law and practice. Sometimes those conversations go well, sometimes they don't. Some of it's about language. Some of it's about simply understanding the problems differently. So we talk sometimes for our undergraduates about commercial awareness to help our students get employment, They have to understand, what are the issues in the oil and gas industry? What are the issues in banking and finance? What are the issues in civil engineering? If you're going to work in those areas of practice, you have to understand, why are clients coming through the door and what are their needs? Sometimes this makes me smile because I think the people that are teaching them their commercial awareness, sometimes we bring in people from outside. We do that much more than we used to. But quite often it's academics having those conversations with their students. And I think, well, what do you know about it? Where's your commercial awareness come from? So I think that's something, is that we could be more open to the world of practice, and there could be more exchange between the academy and the employer in a more humble way. Sometimes academics think we know everything because we've spent a lot of time thinking about some problem or other, but we haven't actually spent 2 days of our lives working in a law office or working in a big corporate, and we could help with that. So we sometimes talk about having practitioners in residence. Well, sometimes the thought is, well, go and spend 6 months working for the of council somewhere and then come back and tell me what you learned. Now, in a sense, that's a kind of weird pro bono that we'd be asking the law firms to do. Just have an academic sit in a corner office for out of the way, just thinking about what you do. That will help us train students better, so they'll be more employable. But you might get something out of it too. Of course, you'd have to put in all kinds of non-disclosure agreements and so on and so on and so on. But just make that relationship a little bit more porous and open.
I really like that.
And the other thing is that we could train people better, I think. When I was, one of my potential careers was to go off and be a civil servant. And one of the things that you do is you're given an in-tray exercise, and you've got more documents than you can possibly read in a day, and you've got an hour. So then you have to chuck out the things that are not urgent or important, identify the things that are urgent and important, write a 1-page which says, well, these are the things we need decision on, and then extract out of that a sentence to say, the key thing today is this, So I have my 400-page book. I need to get that down to a summary of 3 pages, and then I need to say, well, here are the 2 things you need to know. Train people to be able to distill, and then say, okay, that's interesting. Why do you think that? Then you can give people the 2-page version. And if they really want to know that there is a 400-page book behind it.
Thank you. This is called a decent memo. So it's the,
yes.
What's the acronym? The too long didn't read, the TLDR?
Too long didn't read, yes. And that, by the way, is one of the reasons why people are using AIs. I have colleagues already using AIs to summarize each other's emails. Because legal academics write long emails.
So do lawyers. It's kind of like that legal disclaimer we want to add to everything. Listen, I'll write 1 sentence for you, but here's a really long legal disclaimer that's attached to the same email. Okay, so just to keep things. It is good, because it's kind of like academic insight meeting commercial urgency. I believe once you combine the two, you're creating strategic foresight. You're not just asking, what does the law say? Fine, okay, that's fine. But the question is, where is the law going and how do we get ahead of it? That's the biggest question for in-house counsel, is horizon tracking being proactive rather than reactive to what could happen. Because there's new service lines, new innovations, new products that have been created by our clients, which they say, well, I need terms and conditions around it. You go, that's great. Here, a lot of people, when they came with technology, they just came out with the standard services and goods agreement. I said, but that's not fit for purpose. A lot of it we can use, but even the boilerplates will need a bit of tweaking. You go, but what? But boilerplates are boilerplates. Well, if that was the case, everybody would have agreed it, like the one NDA ID that came through in the past, about everybody agreeing to use the same non-disclosure agreement in the world. It didn't really pass through, but it was a very interesting product, very insightful for what they learned from it. But it's the same as SaaS agreement is different to purchasing a distribution agreement, to a reseller agreement, to whatever. So they have similarities, but they're not the same. And sometimes when you pick up the contract, you need to know what's not in there. But when you've got academic research that says, okay, I've looked at where, this technology or this product line is going, and here are the areas which I think the law doesn't actually fit for purpose, like the copyright law, maybe it's not work, or we need to change, update, or we need legislation to change this because it's not going to work on just a case law because it's too confused. Like in law, we spend a lot of time cross-jurisdictional arguing what gross negligence means in a contract, and we say, well, it means nothing in English law, and I'd argue to say in Irish law as well. But there's lots that you could lean on. but there's no court case that will give you a definitive answer just yet. And you go, okay. And then you go to somewhere like Germany, France, Australia, they'll have definitions that use. But in order to do that, you need to keep your mind open. So whilst the academic thinking might say, oh, well, this is the law and this is what it says, and maybe we should have a law reform commission set up to change the law on these areas, and you go, that's great. Change privilege of contract rules since the Third Party Rights Act or whatever. You end up with these little questions which you go, I never thought of it that way. That's interesting. But could I use something from it today? And what you want is that little crib sheet that will say, okay, but until anything changes, might look at 1, 2, and 3. It's probably only going to be 3 because that's the attention span of an in-house lawyer these days. 3 things, and that's it, you move on. But just going back to the original point, it was a halfway decent memo from a junior lawyer, I find, is far more, I was about to say exciting. It's not exciting. It's just, it's nice to receive something that isn't, I'm using the way in which to answer a question in a university exam is different to a memo. Neither incorrect, by the way. You need to write it that way because you need top marks for your exam. But when you need to analyze it for a client just accepts that you know the law. So they don't need to tell them unless it's absolutely necessary because they have no interest in knowing that it's Section 5 of, the 1983 Act. They have no interest in that. What they do want to know is what's the answer. So you need to kind of jump to the answer, the conclusion bit, which is commercially aware, commercially sensible, and extremely short. If you think it's short, make it shorter. That's my
yes,
mantra.
yes.
Because I have to do that to myself. But do you have any final thoughts of this? Because I do have one more question for you, but just on this, because we've covered so much.
We're good at this for the professional year students in our solicitors training course and our barrister training course, because it's formally part of the curriculum that we're expected to deliver, that you learn how to write an advice to clients, you learn how to do legal research and opinion writing and so on. You do those things. We're not so good at undergraduate level. We're still working with some quite, I want to say, old-fashioned ways of assessing legal knowledge around the essay, and we could be a bit more experimental. I think we're going to have to be more experimental because we know that, an AI can generate a standard form university essay more or less at the touch of a button. So we're going to have to be better at assessing skills as well as knowledge, is what I think. But I also think that we need to work smarter ourselves. We need to be, as you say, there is something very pleasing about an elegantly drafted note. And the philosopher Pascal, I think it was, once said, I'm sorry this letter is so long, but I didn't have time to make it shorter. And there's something in that, I think.
Yeah. No, I've even though the podcast go beyond the fine print, I always have a view that the lawyers of the future won't just read the fine print, they'll also rewrite it. So it's very, very important. Let's step away from the world of education and ethics, but ask you a simple question, which I ask all my guests. So what's one thing that people get wrong about your work?
The crucial thing is that they think I stop in May and start again in October, and I have 6 months or so in Tuscany having a nice time. I do not. I work a 365-day year. Maybe not Christmas Day, but it's a job of work and it takes time, and I do it all year round. And that's true of most academics, by the way.
And what's one thing that you find fun about your work?
It might sound weird, but I really enjoy discussions in boardrooms. I really enjoy them because I find them intellectually interesting, because you've got really smart people at the top of their professions thrashing things out and making decisions. And it's very different from a seminar where you're just having a big old debate, because there's a decision. And actually saying, right, this is what we're going to do and this is what we're not going to do. That feels crunchy and real, and it excites me.
Yeah, I think many in-house lawyers will say the same thing. That's the fun bit. Even when the decision isn't what you expected or what you'd agree with, but it's the decision made, so we move forward.
Yeah.
Well, honestly, Richard, thank you very much for giving up your time, your 365-day minus Christmas Day time to join us on Beyond the Fine Print. What I say to everybody listening is, if this episode made you rethink about how we train and trust legal minds, share it with someone who still thinks that hypothetical is enough. If you're an in-house lawyer wondering if law schools are preparing graduates for the real world, ask yourself, would you trust the next hire to negotiate a SAS indemnity clause without crying? If the answer is no, maybe it's time you got more involved with the universities and the law schools out there, because the future legal workforce isn't going to build itself. And if we leave it entirely to academia, we're doing a sterling job, I have to say, we could end up risking that we ending up with lawyers who just quote Bentham but can't redline a supplier contract without a panic attack. We want to be involved, and we should all get involved in supporting our universities, law schools, and other ways of accessing legal education. So whether you're thinking about succession planning or mentoring or just making sure the next trainee knows the difference between commercial awareness or wearing a suit, this is your moment. So on behalf of everybody at Beyond the Fine Print, Richard, thank you very much for your time.
It's been a real pleasure. Thank you for the opportunity.
Well, until next time, stay sharp, stay skeptical, and step boldly beyond the fine print. Thank you, everyone.
Thanks for listening to Beyond the Fine Print. If you've enjoyed the show, be sure to subscribe on your favourite podcast platform so you don't miss the next episode. And if you have any burning questions you want us to cover in a future episode, send them to beyondthefineprint@rmoklegal.com. See you next time.